Arthur.
Sorry, we're starting a few minutes late. We had rather a few judgments to get off our shelves. Mr. Rabinovich knows to some extent.
My Lords, towards the end of yesterday, I was dealing with the question of characterisation. And just
Yes.
to very quickly recap, we say that one has to look at the obligation actually relied on in the claim document because, and this is to use Dr. Scott's terminology, that provides the data or raw material which falls to be characterised autonomously. And if that obligation is a non-contractual obligation in the autonomous European sense, whatever the position in national law, Article 5.1 and Article 18 do not apply. And in that context, I was addressing an example that your Lordships put to me, and I'm going to come back to that in a moment, if I may. Before I do, can I just deal with another point raised by my Lord Sumption, the suggestion that voluntary assumption of responsibility is a peculiarly English analysis of tort law, which is not necessarily adopted in other jurisdictions, and that we were seeking to use that in a jurisdictional context. And it is, of course, right to say, my Lords, that other member states analyse the law of torts differently. But just to be clear, this is not a formulation that we have taken from English law at all. Our test for contract, autonomous contracts, is taken in terms from European cases that I showed you, Lordships, yesterday, which say that a contractual obligation for autonomous European purposes is an obligation freely consented to or voluntarily assumed. Freely consented to is the phrase that one usually finds in the European Court's analysis of this issue. And an obligation which is not freely consented to is regarded as a non-contractual obligation, again for autonomous European purposes. And insofar as your Lordships want examples of cases where one sees this formulation, I took your Lordships yesterday to...
Not consented to, even though there is a parallel contractual obligation which is consented to. So you say that if you have a contractual relationship under which there is an obligation, say, to be honest, but there would be such an obligation imposed by the general law even in the absence of it, the classification for EU purposes is that it is non-contractual.
The classification of the obligation on which you rely, if you're relying on the general principle, is non-contractual.
Understood.
Now, this is a case where we have to, at some point, consider whether your propositions are sufficiently clear for us to decide them.
Indeed, I accept that.
And, I mean, would I be right in saying that, firstly, you can point to no authority directly in point? Can you point to a case where Lord Sumption's scenario applies? There is a parallel contractual duty, paralleling the tortious duty, and the court has said you can plead the tort duty and avoid Article 5.1 or Article 18. And secondly, what about the academic material? Because I certainly don't claim to have looked at it extensively, but looking briefly at Louise Merritt's book, she doesn't agree with your analysis either, well, in relation to that, concurrent duties, or in relation to the distinction between duties imposed by law and duties of a different nature accepted by contract. So, I mean, academic, and incidentally the Heidelberg report, which has some very distinguished authors who are really profoundly steeped in this area of the law, thinks that Article 18 trumps Article 5.3. It may be wrong, and it may seem rather illogical, but it also refers to the issue on concurrent duties as being an open one, and I see cites a German Supreme Court decision, which I haven't had a chance of studying yet. I mean, the Germans obviously think there's something in the point you're making, but is it really clear?
In my respectful submission, my Lord, notwithstanding what your Lordship says, it is clear. And if your Lordship wants authority for the proposition, I've taken your Lordship already to 2 cases, I'm going to take you to more, where the way in which the question is formulated is that you look at the obligation upon which the claim is based and you ask the question that I'm suggesting be asked. Now, Your Lordship says, can I point you to a case where what the court says in terms is, oh, and this is so, even though you could have pleaded this in a contract claim. In my respectful submission, Brogsitter comes the closest to dealing with Your Lordship's point, because what Brogsitter does is to make clear that even in a case like that, the question you ask yourself is by reference to the legal basis upon which the claim is brought, and you ask yourself by reference to the legal basis upon which the claim is brought, whether the contract is indispensable to the determination of the issue arising in respect of that legal basis. Now, again, what that actually does with respect is to reflect the two authorities, and I'm going to take you to one or two more, that make it clear that you focus on the obligation by reference to which the claim is brought. That's why Brogsitter talks about the legal basis. And secondly, it is saying that where the contract is indispensable to the determination of whether that legal basis gives you a claim or not, then it's a contractual claim.
The alternative reading of Brogsitter is that it's always indispensable, that if there is a contract which may or does contain parallel duties, then it's really inappropriate, whatever the domestic law about non-commute, it's really inappropriate to start looking at tort claims in the abstract. For jurisdictional purposes, they must be regarded as contract claims. The contract may be relevant. You look at the English translation is rather inadequate, purpose of the contract, but I wonder whether the better translation wouldn't be object or the subject matter. But object is the word in use in some other countries, and subject matter seems to be the word used in German.
That is, of course, with respect to the alternative reading which my learned friend advances. But certainly he advances it only by ignoring what paragraphs 25 and 26 and 27 say. And in my respectful submission, there's no possible basis upon which that can be an appropriate reading. And once you take into account what paragraphs 25 and 26 say, what possible basis can there be in relation to a judgment where the key reasoning is in 4 paragraphs to ignore 3 of them? In my respectful submission, it is difficult to see why that would be the case, particularly when the 3rd paragraph begins by saying it is therefore for the National Court to do the following. And what it does is to try and encapsulate what it said in the previous 2 paragraphs.
Is the clearest illustration of your argument, not your analysis at any rate of Holterman, because on the facts there was a duty imposed by company law on directors, which appears to have been decisive in leading to the conclusion that it was non-contractual, irrespective of whether there was a corresponding obligation, as one would assume that there was, and as the Dutch courts held that there was, arising under the contract between the directors and the company. Or have I misunderstood the facts?
I'm not sure Your Lordship quite has the facts right. No. When we get to Holterman, what Holterman is actually about, I'll have to come back to it.
I mean, Holterman, they say everything is contractual, don't they? They say
they say everything is contractual.
Directors' obligations as legal persons, the general tort obligation, and the employment contract obligation is all contractual.
The facts of Holterman effectively involved a contract with a holding company, the Dutch holding company, that he act as manager. He was then also appointed as director. What the Dutch court wanted to understand was whether, given the case that he was certainly as manager and there was an employment contract, so that was an Article 18 case, did it mean that in relation to his breach of his duties as a director, you simply treated that as an employment matter as well? Hence the formulation of, does the fact that there's an Article 20 claim preclude 5.1 and 5.3? Now, what the Dutch court, what the ECJ, the Court of Justice, says there is, in effect, without being rude to the Dutch, it says actually you need to analyse the position in relation to the director role from an autonomous European point of view. From an autonomous European point of view, there was a contract in accordance with which he was acting as a director. The claim, as my Lord Reid pointed yesterday, went out yesterday, is one brought in contract for failure to perform certain duties. What the European Court says is that if it turns out that he, qua director, is an employee, then that's within Article 20 because that satisfies the Article 20 requirements. So I don't know whether that's not agreed
So
with.
are you suggesting the result would have been different if he had simply relied on whatever it was, Article 2.9 of the relevant Dutch code?
If he had, well, in the context of that, he couldn't because there was a contract and he was relying on Article 2.9, which applies to contracts. If, your
Well,
lordship,
if he had a right to choose the basis, the obligation that he was relying on, why not?
no, if he had a right to choose the base upon which he was relying on in relation to 2.9, then that would follow. But if your lordship looks at
But
the
why
formula,
didn't he?
because if you look at the formulation of 2.9, that can only apply when there's, from an autonomous European point of view, a contractual relationship.
Right. Right. So it's not a legal obligation imposed irrespective of contract under Dutch law.
Rises consequent on.
Yes, I follow.
What about the general tort obligation under Article 6, 162, which was also embraced as...
That could have been relied upon separately. The Court of Justice doesn't deal with that. The Court of Justice doesn't deal with that separately. But what is clear about the 669 point is that what is being relied upon in relation to the 669 point is that in the performance of his obligations under the contract, he acted in breach of the 669 duty. So the claim there is a contract claim which relies on 669. He could have run his case separately, but he chose not to. So that is perhaps a better example of that. I'll come back to Holterman if I may. What I was dealing with, I think first by way of clarification, is to explain where this phrase, voluntary assumed or freely consented, comes from. I think I mentioned that it comes from Ostra Mekana. That's
Is voluntary assumed and freely consented the same concept?
They are. They're used, sometimes the court uses one, sometimes the court uses the other. But they are intended to encapsulate the same concept. Now, Austro Mekana, which I took you to yesterday, at paragraphs 35 to 38, in particular 35 to 38.
Can you just remind us where it is?
Volume 4, tab 54, page 2383. The relevant passage is at 2404.
But it starts at 2403, doesn't it?
2383 it starts.
No, this part of it, 2403.
2403.
28 and then goes on through to...
Indeed. Sorry, I'm looking for 35 to 38.
Yeah.
It's really, especially 35, you get the formulation there.
The 35 and 36, yeah.
The most well-known case, which encapsulates...
I mean, the difficulty is that it's in the context that Article 5.1 requires you to identify the place of performance of the obligation in question, and therefore you have to ask on what obligation is the claimant's action based, and you've got to read paragraph 36 in the light of paragraph 35, haven't you? And so it doesn't really... Does it really help you in the present context?
Special submission, it does, because matters relating to the contract obviously are limited to contractual obligations, and it's saying you have to identify the obligation on which the claim is based in order to come within 5.1. In my respectful submission, that is exactly in line with what we're saying. Can I give you some examples? I just wanted to give you one more reference. The other case...
It doesn't really address the question whether you can avoid Article 5.1 when your cause of action is by putting it in tort, though, does it? It's just simply not addressing that point.
No, it's not addressing that point, but it's establishing a general principle. Yeah. And if it's establishing a general principle, the fact that you have different facts which arise doesn't mean that the general principle still doesn't apply. This is the general principle. One has it in about 5 or 6 cases.
Yes, but I think the point that can be made against you, as I see it, perhaps putting it over simply, that because we have a system whereby you can put your claim in more than one way, can it be said that you can, although your claim on the face of it is in contract, you can put it in tort and thereby avoid the effect of the regulation? Is there any case that face it up to that point? 'Cause
Well,
that's a slightly unkind way of putting it,
No,
but it may be a fair way of putting it.
It has a lot of these cases, in my respect for submission, face up to that point, because effectively what is happening in a lot of these cases, including Holterman is an example of this, and perhaps Brogsitter as well, although we don't know the answer in Brogsitter, you have a claim which under the local law, the national law, is formulated as a non-contractual claim. And what the court says is the fact that you formulate it as a non-contractual claim doesn't mean that it is a non-contractual claim. Whether or not it is a non-contractual claim will depend upon whether the obligation upon which you rely is one which is voluntarily assumed or freely consented to. So in that sense, the point my Lord Newbigger raises with me is dealt with. And the answer to the point about can you get away from contract is to say, well, not if the obligation upon which you rely is in fact contractual in nature.
Plainly.
Because you can dress it up in whatever way you like, or you can try and dress it up in whatever way you like under local law. But if, in fact, from an autonomous European point of view, it is contractual, it will be a contractual claim. But equally, if it's not, it won't be.
I mean, this ultimately depends on whether the EU rules of classification are seeking to classify the relationship or the particular obligation arising out of it in circumstances where there may, under national law, be more than one obligation that arises out of it.
Indeed. And one will not find anywhere, and bear in mind, my Lord, that we're dealing with here an issue which arises in relation to the matter relating to contract point. In other words, this isn't just about employment. It's about any contractual relationship. What you will not find anywhere is anything which supports my learned friend's position, that you always look to the relationship in question. In fact, Brogsitter authority against that. So the fact that you have a contract is neither here nor there.
But your submission about whether the principle that you argue for has the requisite degree of clarity is very heavily dependent on the notion that Article 18 is a subset of Article 5, so that the authorities on Article 5 versus 5.1 versus 5.3 can be carried across.
It is, and in my respectful submission, that is clear. My learned friend says very little about it. He accepts our historical analysis. He relies on GlaxoSmithKline as his main case for saying, well, things have changed. But when one goes to GlaxoSmithKline, one sees what they're saying is the only thing that has changed is that a provision which was previously in Article 5.1 is now in a separate section which has additional parts to it. And what has changed is the addition of the additional parts. The wording isn't the same. Sorry, the wording isn't different at all. And if my learned friend is right, one really does have to ask oneself, does he say that a matter relating to an individual contract of employment, the test for that, as it appeared when that language appeared in the 1988 Lugano Convention, gave rise to certain results, and that the results suddenly changed as soon as the exact same words were put in a different section? Because that is what he has to say. And certainly GlaxoSmithKline is no authority for that. I've taken your lordships to Professor Harris, who makes it clear that this was just a tidying up. Generally, there is nothing anywhere which suggests that a radical change was intended here. So one also sees, and I'm just repeating myself.
This is a simple point, is it, that there's no difference in principle between the expression in matters relating to a contract and in matters relating to individual contracts of employment?
It's a subcategory.
The relationship must be the same.
Exactly. It's a subcategory of a contract. It's a type of contract. And just because it's a particular type of contract doesn't mean that the test, whether it is a matter relating to, suddenly changes. Now, my learned friend has said that everything changes because we're now, Recital 13 says we care about employees just as we care about consumers. But I've taken your lordship to authority which says that has to be narrowly construed, and your lordship will remember the case of Gabriel, where notwithstanding one was dealing with a category of case where people were intended to be protected. Again, the Court of Justice said in that case, was this a contract claim or a tort claim? That was Gabriel, which is in the the appellant's additional authorities. I think it was paragraph 32. Can I just go over some examples just to illustrate the point? And in my respectful submission, they bring out, in my respectful submission, why what my learned friend says is very unlikely to be right.
But before we turn to the new examples, could I...
I'm going to go back to the old
well,
example.
if you wouldn't mind going back to an old one just for a moment. In Holterman, I wondered whether the discussion of a third question wasn't relevant here. It's tab 51 in volume 4, page 2356. One sees in paragraph 66 that the third question is interpreted as meaning that inasmuch as national law makes it possible to commence legal proceedings simultaneously on the basis of a contractual relationship and of tort, does Article 3 cover a situation such as this, where a company is suing a person both in his capacity as manager and on the basis of wrongful conduct. And we see the answer eventually in paragraph 71 really tells us the answer. If the conduct complained of may be considered a breach of a manager's contract, it must be concluded that the court's jurisdiction is the one specified in Article 5.1. And that's paragraph 71. That's in the context where national law makes it possible to base a claim by the company on allegedly wrongful conduct.
It sees there the reference to paragraphs 24 to 27 of Broxeter.
Yep.
And in our respectful submission, what is actually happening there, and this is reflected also in what the Advocate General said, is everyone is using that formulation as shorthand for paragraphs 24 to 27. So that when one reads that, one is told, and in my respectful submission, this is a point in our favour, go to paragraphs 24 to 27 and see whether it works.
Well, they're not saying, they're not referring, they're laying down a principle and then referring to Broxeter as an analogy.
But the language is taken from Broxeter, my lord. And in the context in which they're dealing with this, they must be, in my respectful submission, making the point that Broxeter, when you're in the question of 5.1 and 5.3, look at Broxeter paragraphs 24 to 27, which will give you the answer whether there's a 5.1 or a 5.3 claim.
Does paragraph 70 is that not quite important here? Inasmuch as national law makes it possible to base a claim on allegedly wrongful conduct, such a claim may come under tort for the purposes of 5.3 only if it does not concern the legal relationship of a contractual nature.
And that is saying that the claim must not concern that matter. In other words, again, looking at what you are claiming and saying, does that invoke the contract? Because if the claim doesn't invoke the contract, as, for example, a claim in deceit, even if it's between contracting parties, or a claim in conspiracy, even if it's between contracting parties, then you're not concerned with the contract.
Well, 71 focuses on the conduct complained of rather than how the claim is put in law.
Isn't that the conduct complained of in the claim?
Yeah.
So one, again, is directed towards what you are relying upon in the claim.
It all depends whether it means the conduct complained of, i.e. the facts, or the facts as analysed as a matter of law in the claim. You're saying it means the latter.
Indeed.
What's being put to you is it might mean the former.
Yeah.
In my respectful submission, my lord, it does mean the
Perhaps
latter.
we should refer the whole matter now and go home.
Well, if your lordships are against me and you think, notwithstanding anything I say, it's going to lack clarity,
It should be referred, should it?
if I'm wrong, it should be referred.
Well, clearly, both of you say you're plainly right, but if you're not, it ought to be referred. They're perfectly fair position to take.
In every case, more or less.
Can I just show your lordship what Dr. Scott says about the relevance of pleadings? This may help in relation to the point that my Lord Reid raised with me. It's volume 8.
I mean, just before we go there, if you read on in the part of the judgment in Holterman that Lord Reid refers to, you go on to paragraph 73, and so on. It talks about the court to a place where the harmful event occurred particularly appropriate, which suggests it might be said that they're looking at the factual matters alleged, not necessarily the legal basis on which the claim is put. But you can say that they're concerned perhaps with a slightly different point, but the flavour of it.
Well, with respect, my Lord, I don't see why that is limited to saying you're just looking at the facts, as opposed to the obligations which you are relying upon in support of your claim.
Because the dispute could be a dispute over the terms of the contract, whereas if you don't have an issue on the contract, etc. So I see the point, yeah.
I mean, when you look at paragraph, I'm sorry, if you look at the actual ruling on 2358 and paragraph 3, we're told that Article 5.3 must be interpreted as meaning that the action is a matter relating to tort, where the conduct, we'll get back to the words, the conduct complained of, may not be considered to be a breach of a manager's obligations under, in this case, company law. And if the conduct complained of doesn't simply mean the facts, but means the facts, the legal characterization of the facts under domestic law, then the answer becomes circular. Because, we then go on to domestic law in the words that immediately follow.
Sorry, if it doesn't mean the.
Well, I mean, I would have thought the words "the conduct complained of" must be read as referring to the facts.
Yes.
Because then you then turn to the question of how they can be characterized under domestic law. But if the words "conduct complained of" simply mean the facts, then this would seem to be an authority which is awkward for your argument.
I don't think one is characterizing at any stage the position under domestic law here. One is trying to characterize the position as a matter of European law rather than domestic law. And what one is trying to characterize is the claim, including the matters complained of. But it is difficult to see how, take the contract situation, you can say that the court is not having regard to the obligations as well as the facts, if the approach that the court has consistently taken is to say, have a look at the obligation and decide whether it's contractual. That just, with respect, doesn't work. I was going to invite your lordships to go to Dr. Scott in volume 8, tab 87, page 3578. In our written case, we've suggested that your lordships read, I think, from paragraph 57 to 72.
Sorry, 57? Oh, pages.
72, internal pages. The extract I was going to show your lordships now, for present purposes, is a 3578. Now, this is dealing with the question that arises in the context of choice of law, which your lordship sees the point is the same. Just picking it up in the second line, since the regulation is talking about Rome 2, focuses on obligations and the events out of which they arise, these provide the data for characterization. The regulation looks at nothing else. Given the questions asked by the regulation's rules and concepts, such data must include an obligation's nature, incidence, and constitutive elements of the events from which they arise. It is submitted that the only law that can provide these data is the law by reference to which the claimant pleads his case. Now, he says there the regulation focuses on obligation and the events out of which they arise. So too does the Brussels regulation or the Lugano regulation. And just reading on, however, whilst data used in the characterization process are derived from the law by reference to which the claimant pleads his claim, this does not mean that the law's characterization is adopted. For example, if a claim is brought to enforce obligations arising under the principle in Headley, Byrne and Heller, the obligations alleged may not attract the regulation's rules. Although English law classifies those obligations as tortious, they arise under that law from voluntary assumptions of responsibility and can be disclaimed or varied by the defendant's contrary intention. The incidents and constitutive elements of the obligations under English law would take them outside of the regulation scope if, for example, the autonomously defined concept of non-contractual excludes obligations arising consensually. My Lord, just point's been made by Mr. Fulbro and correctly. If the reference that your Lordship makes to the paragraph of Holtman really does mean you can ignore the obligations.
Does really mean?
You can ignore the obligations in the characterization process. Then what the court in Holtman has done is to simply throw away all the authorities that preceded it, which provided an indication as to how one goes about the characterization process.
You're referring to cases like Ostro, Mechana, and OFAB and so on, are you?
Indeed.
Right.
And I would respectfully submit even Broxeter, because that also focuses on the legal basis.
Well,
You just give us the reference again to Broxeter.
It's 445,
Thanks.
and it's page 2245, the relevant passage 2250. Can I just go back to the example that I think my Lord Sumption put to me yesterday about a person employed as a chauffeur who drives a car negligently causing personal injury to his employer. The employer then sues for damages. In our submission, this claim would fall within 5.1, but only if the obligation on which the employer actually relies, is a contractual obligation in the autonomous European sense.
so suppose that the position was that it was both a breach of his contract and, contrary, the accident having taken place in Calais, to a mandatory provision of French law under which negligent drivers are liable to their passengers, whether the passengers happen to be in a contractual relationship with them or not. Now, your submission, as I understand it, is that in that case, you select the obligation you wish to rely on. The EU classification process then requires you to analyze the particular obligation in terms of its own rule about whether that is contractual. You say it's got to be indispensable to establish the contractual liability in order to make good the unlawfulness alleged. But that is your submission, isn't it? That you can do either.
That is my submission. That is my submission. The only thing I'd add, with respect to your Lordship has it right, the only thing I'd add is what the European Court does in deciding whether it's autonomously contractual. Me having selected what I wanted to select is ask whether the obligation I'm relying upon is one which is freely consented to or voluntary.
Well, your reservation is that something may be non-contractual in national law, French or English, but nevertheless contractual if the sole basis on which such an obligation exists is that it has been mutually consensually assumed.
Precisely. And that's Granarola is an example of that.
Well, if one can understand it, it is.
Well, that's what they appear to be saying there. But let's take the example of the employer who is injured by his chauffeur, who chooses to sue under, as my Lord Sumption puts it, a general mandatory provision which says people who are negligent in driving shall be liable for damages. Chooses to sue under that provision. That, in our respectful submission, is just not a contractual claim. The fact that he could have brought a contractual claim doesn't turn that into a contractual claim for the purposes of characterization at jurisdiction level. Take this example. Let's say instead of there only being one person in the car, there's the employer and a guest, a third party. Again, in a system which has a statute which says people who drive negligently will be responsible to compensate anyone who's injured. The passenger relies on this provision, plainly a tort claim.
Yes.
The employer relies on exactly the same provision. The Learned Friend's argument requires that one say, even though arising out of exactly the same facts, exactly the same accident, rely on exactly the same provision, just by virtue of him having a contract with the driver, you have to characterize the one as a contract claim and the other as a tort claim, even if I rely only on the statute that my passenger is relying on.
And that effectively means that the existence of the contract provides a jurisdictional immunity.
Exactly that. Whether or not I'm relying on it. And one has to have in mind that the point my learned friend argues for is not just one which relates to employment contracts. This is a threshold point which relates to 5.1 as well.
Yeah.
So take a different example. Take the example of a taxi driver. I get into a taxi, he smashes. Now, maybe from an English point of view, but certainly from a European point of view, you could argue that there's an autonomous contract there because he agreed to take me somewhere voluntarily. I want to sue him in tort. He's done me a lot of damage, and there is a provision in the law which says anyone who's a negligent driver can be sued in tort. The learned friend is right. I can't bring a tort claim. I can't bring a claim. That means I can't bring a claim in the place where the damage was suffered. Well, I can bring a claim, but I can't because it'll be moved somewhere else. He says characterize it.
Surely the remedy for your point in the ordinary tort contract situation where there's no question of employment is Article 6. You can join, you can establish the claim against the passenger in the place where the injury is caused. You can join.
You can't under the Lugano Convention because Article 6.
Sorry, it's the other way around. You're quite right. Anyway, so we were talking about injured passengers. Yes.
If you had to establish that you were in the cab lawfully, arguably you could say you would have to say why you were in the cab. You would have to rely on the contract that he let you in.
But that can't turn what would otherwise, because he raises that as a defence, that can't turn what is a tort claim in negligence.
It isn't a necessary ingredient, but it's very much part of the story. I was in the cab because I heard him.
It may be part of the story.
Coyley wouldn't say that because that would then make it part of the claim.
That leaves it in the hands of the taxi driver there as to whether to take that point or not. And so he can affect jurisdiction by raising a contract point. Take a different example, which illustrates a similar point to the one Malone Friend's making.
Can we just have the example? Who is suing who in the taxi cab driver?
The passenger's suing the
passenger's suing the driver. There's a contract either way.
He's suing him in tort. He could have sued him in contract instead or in addition, but he's not doing so.
He's not doing
so. You
so.
say it's a tort claim, caddy question.
Well, it's a tort claim, and the point about that is it shows it's really to bring it away from the employment situation because one starts saying, well, this is unfair to an employee. Right. But with respect, I'm not saying it's never irrelevant that you're being unfair to an employee. We just say we're not. Yeah. We say the statute provides protection for employees if you come within a particular
I don't understand
scope.
what the problem is with the taxi driver because inevitably the place for performance of the contract will be where the accident takes place. So Article 5.1, 5.3 doesn't matter. What is the notional problem?
Well, the problem is that a claim which certainly looks, I would suggest, as if it should be a tort claim and where I should be free to bring a tort claim if that's what I want to do, is recharacterise the my learned friends test as a contract claim just because I got into the taxi.
I'm not sure it is obvious that it should be a tort claim. I mean, if I hire a car, that's clearly, with a driver, that's clearly a contract claim. Why is it different if I get in a taxi? I clearly contract with the taxi driver.
Even if I'm relying on a statute which operates regardless of the existence of a contract.
Or the common law, would you say the same thing if it was simply relying on the common law duty of care?
Yes, I would.
I mean, if it's a separate statutory duty, rather like the duties which are imposed on some employers, even unfair dismissal, you might have a question. There's no contractual homologue. But if it's actually the duty which you undertake when you enter into a contract, namely to be careful, I don't see why you should evade it or be able to bypass it by suing in tort.
Well, your Lordship says bypass it. I mean, what my learned friend can't point to is anything in anything in choice of law circumstances or anything in any of the authorities in jurisdiction circumstances which has this bypass, non-cumul approach.
I wonder whether you need to go as far as you are going in your answers to my lord. Suppose you take just a classic case in which there is a contractual duty of care as well as a duty of care in a Henderson and Merritt type case. Now, there are two obligations legally distinct in English law, but both of them depend on a consensual assumption of responsibility. And so the answer on the face of it would be that in that case, it is contractual because it is wholly dependent on the assumption of contractual responsibility. The tort obligation goes no wider than the contract, as Henderson and Merritt makes clear, so that this is a point that you can give away without, so to speak, throwing the baby out as well.
I'm happy to give that point away. I think my Lord Mance goes further, and my Lord Mance wants to say that even if I'm relying on the statute which gives a claim against anyone who is negligent in driving and does damage to you, just because I got into a car and it might be said there was a contract between us, I am precluded from relying on that statute as a tort claim, and my claim will have to be a contract claim.
Yeah, I mean, the better opposing position is the example of the chauffeur driving you about Calais, assuming there to be a statutory obligation to. But I mean, it may be that a more likely example is to distinguish between deceit and negligence.
Precisely.
Because deceit is an obligation which, although it may be a breach of contract, would exist irrespective of any contractual or consensual assumption of liability.
Precisely that, my Lord.
Whereas negligence would not.
And that is, the deceit example is one that we take.
One that you raise in your case.
And
Is it a sleight of hand here? Because we're confusing what we call an assumption of responsibility, which gives rise to a claim in negligence, with the autonomous concept in Europe, where it doesn't.
Well, I'm not sure that is a sleight of hand, because effectively what the Europeans would do is autonomously characterize that claim, however you put, as a contract claim, because it was based on a voluntary assumption of responsibility.
Voluntary assumption of responsibility is a slightly unfortunate expression to use, because in an English lawyer's mind, it immediately flags up Annes and Merton Borough Council and all those other, and Smith and Bush. It's really a consensually assumed obligation, regardless of whether the national law characterizes that with a capital C as a contract. And it has to go down that road, because in many civil law countries, contractual obligations are either irrelevant because the whole thing is taken over by regulation, or non-existent because of rules about formalities of concluding contracts.
Yes, but the negligence case we're talking about in English law does not involve a voluntary assumption of responsibility in the autonomous meaning of that expression in Europe, does it?
I think it does.
I think it does.
Can my lord?
Well, it does, the duty in negligence does not involve the sort of assumption of responsibility that they're talking about in Europe.
It only exists, doesn't it, because you have consensually agreed to get into this man's cab, and he has consensually agreed to drive you somewhere and smashes up on the way.
Well, in that case, you have to rely on the contract, don't you?
In that case, you are, well, in a sense, I don't mind whether you rely on that contract or not, my lord, because my example doesn't depend upon showing the outcome one way or the other for negligence. What my Lord assumption says, in my respectful submission rightly, is you really see the contrast when the claim is in deceit. Because where you have a claim based in deceit, the question arises as to whether I have to recharacterize that claim, a claim in deceit, i.e. for dishonesty, as a contract claim, simply because there is a contract between the parties into which someone might imply a duty of honesty.
But why is that any different from the negligence point?
Because it's only different in this sense. In the negligence point, it's very easy to slide over from voluntary assumption of responsibility in the English sense to freely assumed in the European sense.
Why does that make it a relevant difference between negligence and
it's only
deceit?
easier. I'm not saying it's relevant. I'm saying the one example is easier to understand than the other example because one doesn't get caught up in the overlap between
But the distinction, surely, is that the obligation that you're relying on when you plead deceit is an obligation which exists regardless of the relationship between the parties, whereas the obligation to drive carefully only exists because of the relationship between the parties. And EU law says that because that relationship, in the relevant respect, is consensual on both sides, that's why you classify it as contractual. The logic wouldn't apply to deceit.
It wouldn't apply to deceit, correct?
Yeah, and if one took that line of argument, then might the present case fall in the middle? Because here, the obligation said to be breached is, what is said to have happened is that there's a conspiracy to cause harm, but the essence of the conspiracy is one which is said to involve breach of the terms on which they were acting as directors, agents, employees, or whatever. So it's difficult to separate. They obviously voluntarily agreed to undertake the roles they did. It's quite difficult to say that you can step outside a contractual analysis by focusing on the fact that they agreed to breach their agency, employee, directorship duties in conjunction, in conspiracy with others.
My respectful submission, my lord, if they are these two categories, then a claim in conspiracy falls very squarely in the context of claims where the contract is not indispensable because it exists independently of whether
if you can show that there was one conspirator who's not an agent, director, employee, you step outside the fact.
Not relying on the fact that
or if
they
you can
are
show that you conspired with another director who was a director, owed the same duties, you step in.
It doesn't depend on numbers. My case depends on the concept of a conspiracy because the concept of a conspiracy does not depend on the existence of a contract for the existence of that obligation.
No, but the unlawfulness of the conspiracy depends upon the fact that you are conspiring to breach all sorts of duties which you owe as a director, agent, employee.
Which may or may not have involved that. But the cause of action, the obligation, is one not to conspire.
Well, the illegal means is that Mr. Foxton's client stole the money. Not to put too fine a point on it.
That is right. And the fact that...
Stealing money is, on the whole, an activity that's disapproved of, whether there's a contract or not.
That's right. That's ultimately what this is about, which is why the other claims fall in the same category.
Driving carelessly, too.
Can I Well, that, as I say, is what we say. We say you have to distinguish between, your Lordships know, we say you have to distinguish between whether the obligation is an independent obligation or one that derives from contract and where you're relying on the contract for the purposes of your claim. Now,
Can I ask you a related but different question? Do you rely on what one might call the commission point in Holterman? As I understand the commission point, and I may have misunderstood it, it is that if the problem has arisen because of the employee's influence or control over the management of the company, it effectively is taken outside the realm of contract of employment cases, because although there is a contract, when you assume control of a company or influence, and you use that control or influence to direct the company to misapply its funds or do some other wrongful thing, you are effectively not in the relevant respect doing something that depends for its unlawfulness on its being a breach of contract, which would not be the case if you were basically a company chauffeur who drove into a lamppost. And that is what I understand the Commission to be saying. One, is that what you submit the Commission is saying? Two, is that proposition accepted by the court in Holterman? Three, do you rely on it if so?
yes, and yes. That is what we submit the Commission was saying. That is what we submit the court is also saying in paragraphs really from 33 all the way to 46, 47. And in our respectful submission, when you come to the facts of this case, where you have parties who do control the companies, they decide the terms on which they're going to contract, they decide with whom they're going to contract. You are not within the protection that the Article 18 to 20 is intended to provide. I was going to deal with that in the context of breach of fiduciary duty, but the same point equally applies to the conspiracy claim. Can I, just going back to where we were, and we've, I think, made a lot of ground, make this point. I took you to two authorities on the point that we rely on, which is that it is clear European law that what you look at is the claim actually made, and you look at the obligation relied upon, and you characterize that. I took you to OFAB, and I took you to Austro-Meccana. Can I give you the references for the others, because they tend to say the same thing? The third case is Ergo Insurance. That is 452-2359, paragraph 44, which your Lordships will find at 2370.
Thank you.
That is a choice of law case. My learned friend, when he made his submissions yesterday, suggested that the vast bulk of the authority that I rely upon, or can be relied on, for the proposition I make come out of choice of law cases. With respect, that's not right. The only one that we rely on, which is a choice of law case, is Ergo Insurance.
Thank you.
In addition, your Lordships may also want to look at Kalasa, which is,
Yes.
I think, is a 2015 or 2016 case.
Yeah, we looked at that.
Yeah. The relevant passage here is paragraph 39.
Yes.
So Kalasa is 4, tab 50, page 2288. Paragraph 39 is at 2318.
Thank you.
Your Lordships may also wish to look at VFK. That's 3, tab 37, page 2067, paragraphs 36 to 39. That's at page 2087 for those paragraphs. 2087.
Thank you.
And Advocate General Heelgoed in Taccone. What? I don't know how you would pronounce it in English, but in Dutch it's probably Heelgoed, Taccone, Tacconi. That's in the Respondent's Authority, tab 5, page 78. Yeah. I might just take your lordships to this, paragraph 36. So respondents' authorities, tab 5, page 78. It's paragraph 36 on page 87.
We haven't got tabs, sorry, in your...
Page
Oh,
87.
no, I beg your pardon, I'm looking at the wrong one.
By respondents.
Respondent supplementary authorities, tab 5.
Supplemental authorities.
Yeah.
Page,
You have tab 5, page 87.
thank you. Paragraph,
36.
thank you. Yeah,
Under Article 5.1, a person may, in matters relating to a contract, be sued in the court for the place of performance of the obligation in question. The phrase matters relating to a contract is to be understood as meaning the contractual obligation which forms the actual basis of the legal proceedings. In the case of a claim based on different obligations, which are probably to be performed at different places, the obligation which characterizes the contract is to be taken into account. My learned friend wants me to read paragraph 34 to you. In his recent opinion in Gabriel, Advocate General Jacobs disputes the contention that community law contains a general principle that any derogation must be interpreted restrictively. In general, I share his view. However, as regards Article 5 of the Convention, the need for restrictive interpretation is not at issue. The need stems independently from the objectives of the Convention, that is to say, to protect legal certainty. I'm not sure where that point is supposed to go, but if it's a point which is intended to suggest that Article 5, or indeed Section 5, is not to be construed narrowly as a derogation, then with respect it is inconsistent with a number of the authorities I took you to, including yesterday, including Colasso.
Do we have the judgment of the court in Tacconi?
We do.
Does it deal with the point made in paragraph 36 by the Advocate General?
Come back to that, my lord. Some of them.
But again, this is in the context of applying Article 5.1. It's not i.e. deciding which country or court has jurisdiction, isn't it? What was the actual issue in the case?
It says in the context of applying Article 5.1.
In order to decide which court Article 5.1 applies to, you have to work out which obligation is in question.
That's precisely what we're doing here. We are trying to work out which court has jurisdiction, and we're trying to identify the proper test for characterizing claims. For
Yeah, but if an obligation is in question, the question we're dealing with is whether you can avoid Article 5.1 altogether by not putting it into question, but basing your claim on allegations of independent tort, and that is a different question. I'm just seeing whether you get some assistance on that. Yeah.
Kenny was concerned, if your lordship go to volume 3, tab 36,
Pre-contractual. Yeah.
page 2063.
Volume
Tab
36.
Volume 3, tab 36. It starts at 2061.
And is there anything that reflects the line of reasoning of the Advocate General at paragraph 36?
Your lordships look at paragraphs 24 and 25. This is a decision which the court held that pre-contractual fault is not a matter falling within Article 5.1 because the obligation relied upon is not contractual.
Well, because there was no obligation freely assumed.
It's pre-contractual. That's a very good illustration of the position.
This was Yes, but it might have been different if it was a Headley Byrne type representation, a misrepresentation that was in issue, because this is a claim for unjustified breaking off of negotiations.
It's a breach of an obligation under the Italian Civil Code to act in good faith in the course of negotiations before a contract is made, therefore incapable of being contractual.
So because the obligation relied upon exists independently of the contract, it was not contractual. In our respect for submission, that
but there was no
rather well
contract.
illustrates the point we're trying to make.
We'll accept that this was a case in which it would have been impossible to rely on a contractual obligation because there was no contract. The complaint was they'd never entered into one.
Well, it's not, I mean, they're obviously not saying that, they don't go that far, but it's perfectly possible to conceive. And what one doesn't find in any of these cases is anyone saying, have you investigated whether you could find a contract by reference to which, an autonomous European contract by reference to which you could have pleaded this claim? Because if you can, then you can't bring it in tort. So in Tacconi, for example, what you don't find is any analysis of the question of whether, notwithstanding that it was pre-contractual for the contract in question, there may have been a voluntary agreement that they would negotiate, and that became contractual, albeit it was a collateral contract. Now, no one goes into that kind of analysis because it is irrelevant, because no one is asking the question as to whether you could have pleaded this in contract, albeit a collateral contract. Can I
Seems to me
just...
it's almost cuts again.
Learned Friend took you to De Bleus, that is another authority, volume 3, tab 28, page 19, it's paragraphs 11 to 14. And we submit that that long line of authority establishes the proposition for which we contend. Now, that is what we say, and just to be clear, I think your lordships have this point, although we're criticised for adopting a parochial national law approach to the question of contract and torts. That is not at all what we're doing. We say the claim and the claim form and how you put your obligations is not determinative. What matters is how European law will characterize the claim, but it is the source of the data which you are seeking to characterize.
You don't look at the national law, but you look at the national pleading, as it
You look
were.
at the national pleading, and the national pleading will have been affected by the national law.
course.
I think that's the point that Dr. Scott makes. Can I say this, that although, as I say, we have a great deal of authority in support of our position, Learned Friend can identify nothing in support of his position. Unless, as I say, we'll come to it, you read Broxeter by ignoring 3 paragraphs.
Yeah.
So if the choice is between those two approaches, do you look at the claim as actually made and characterize the obligation on which the claim is actually made? Or do you instead look at the claim which is made and ask yourself the question, could this claim have been pleaded in contract? Our approach does have authority, my learned friend's approach doesn't. Now, can I then move on to a few points as to the anomalies that would arise on my learned friend's approach? Because, as I say, if they're wrong about the test, then in our respectful submission it follows that our test is, as the authorities seem to suggest, the correct one. The first anomaly or point that we would make about my learned friend's test is that if that were the test, it would be potentially very wide indeed and would capture all sorts of claims that one would not expect to be captured. As my learned friend, I think, accepted in the Court of Appeal, it would capture any form of skullduggery or dishonesty and make it a contract claim. So a number of straightforward tort claims become recharacterized as contract claims. And that obviously is not just the position in relation to employment, it is what my learned friend says should apply to all Article 5.1 claims. That is, follows from the fact that he relies on Broxeter for this proposition. And again, going back to the example which your lordships have raised with me already, a fraudulent statement, a claim for deceit, one would expect that to be a tort claim, but on the basis of my learned friend's case, if you were operating in a system of law where you could imply a term of honesty, then it would become a contract claim. Certainly there are English authorities at first instance which suggest that that would be wrong. We've got in the bundles Alfred Dunhill, Volume 1, Tab 8, page 1240 at page 1252 at 961F.
But so too would the sort of claim that's heard in tribunals in this country involving employees for putting their hand in their till, where there's some dismissal allegation. But that sort of case would, you would say, would you, that a claim against an employee for defalcation is necessarily or can be pleaded as a tort claim?
Or can be pleaded as a tort claim. I'm not saying it necessarily has to be.
That's quite serious inroad into the protection of employees. So the employee will no doubt say, I did nothing of the sort, and you wrongly dismissed me. The jurisdictional basis becomes totally different simply because...
Leonard Friend's point isn't just about employees. His point is about all contracts.
Yes.
So one has to test that, not by reference to employees. If an employee finds that he is within the scope of Articles 18 to 20, then he gets the protection.
Yeah,
but he
you
can't
say
say that
he
because I am an employee, I'm entitled to the protection, whatever the nature of the claim I've done. If the nature of the claim is one which arises solely by reason of that contract of employment, so it is about the contract of employment and his performance of the contract of employment, he gets the protection. But if it's not about that...
So the same applies between contracting parties. As soon as you start to raise allegations of failure to account against an agent, a deliberate failure to account, you're in the tort area, whereas if it's ordinary failure to account, you'd be in the contract area.
If what you're doing is relying on an obligation which arises under the contract, you're in the contract. If you're not relying on an obligation which arises under the contract, then you're not. And there is, as I say, nothing in European law which says that it is not open to you to decide what claim you want to bring. Take another example, and this is an example that we take from Plender. One employee assaults another employee at work. Now, the employee who's been assaulted and injured could bring a claim against the employer on the grounds of vicarious liability, and one would expect that to be a tort claim. In my learned friend's case, however, since you could plead the claim as a breach of duty to provide a safe place at work, and therefore you could plead it as a contract claim, on my learned friend's case, that would have to be brought as a contract claim. That's, as I say, we've taken from Plender, Volume 8, Tab 86, 3571. It's paragraphs 2065, 2066, 357.
2056.
2065, 2066. And your Lordships will recall Lord Justice Gross in the Court of Appeal noted that my learned friend's test was, as he described it, of potentially unacceptable width. And we respectfully submit that that is right. Just taking this quickly, because I may start running out of time soon. A second point we would make about this is as follows. My learned friend's test would, we submit, be very difficult to apply. And that is because he posits a situation in which the court seized would need to investigate A, what was the proper law of any contract? B, whether under the proper law the matter could be pleaded as a contract claim. And C, whether what might be claimed under the alleged implied term that might have been relied upon would constitute a breach of that term, implied or otherwise. And in our respectful submission, that gives rise to the possibility of real complications requiring evidence of foreign law to be considered and determined, just to deal with this point about what might have been pleaded. My learned friend, when dealing...
Doesn't this depart from... I mean, I thought he said that the contract was all autonomous, so you wouldn't be investigating the proper law domestically, would you? You'd just be looking and saying, is this something which we regard as having arisen out of the voluntary acceptance of an office?
Well, your lordship would look at the data that's being relied upon in the claim. My learned friend says, and so that is what is characterised autonomously. But you would still have to investigate. And my learned friend's case is not clear about this. Is he saying that the implied term is one that you have regarded as a matter of the autonomous contract, or is it just something which applies where you're not dealing with an autonomous contract and you're dealing with an actual contract? Because unless it's not clear, his test could only work when you are dealing with an actual contract rather than the autonomous contract.
I don't understand that, because as I understand it, Article 5(1) and 3 requires you to think autonomously. Whatever the national categorisation, you have to decide whether in European terms this is a contract or tort situation. Yeah. So why do you go further than that? Why do you investigate proper law?
Well, because my learned friend's test is to say, take this case. This case, there's common ground that there could be an implied term of honesty. Let's say it wasn't common ground. We go before the court and we're relying on an obligation which on its face is a tort obligation. My learned friend wants to say, never mind that you're relying on a tort obligation, you could have pleaded a contract obligation, and although there may not be a term in the contract dealing with this, as a matter of the proper law of that contract, which he says exists, you could have pleaded this as an implied term. His test posits that you would only characterise this as a contract claim if it was capable of being pleaded as a contract.
I don't think that's right, because he relies above all on Holterman, and some of the matters swept up in Holterman as contractual claims were by definition incapable of being pleaded in contract. Take the Article 6, paragraph 162, the general tort obligation. You couldn't plead that as a contract claim.
The learned friend,
the court said this is all under the head of voluntary assumption. It arises from your assumption of your office.
Learned friend said, when he took your lordships to Holterman, that he accepted that in relation to Holterman, exactly the same test would apply in relation to Article 20, which is to say you cannot come within Article 20 unless you can show that the obligation, that the claim is brought on a basis where you could have brought it as a breach of contract claim.
But as I read Holterman, they simply say that, well, I mean, paragraph 49 seems to be pretty clear. In a situation in which a company sues a person who performed duties of director and manager in order to establish misconduct in the performance of his duties and to obtain redress, Section 5 precludes the application of Article 5, 1 and 3.
Which paragraph was that?
Paragraph 49.
Yeah.
What is that saying? It is saying, all it's doing is dealing with the facts of Holterman, where in fact you had a claim where the European court said this was a contractual claim in nature, whatever your, however you may characterise it under national law.
I'm not sure it does say that. It's I'm not sure if they go into the question about effective. I think Holterman seems to me to place in question your premise that Article 18 cases are really a subset of Article 5(1) cases.
Well, in my respectful submission, the reason, with respect, I don't accept what your lordship says is because, as my learned friend accepts, when you start at paragraph 32 and there's a reference to Holterman, that is intended to be relevant to all three questions that the court is dealing with. So the court proceeds, a reference to Brogsitter. That is an acknowledgement that what the determination of the article, the first question, is also going to turn on Brogsitter. The analysis that the court actually undertakes in relation to the first question involves the following. It says this is a contract claim because as a matter of European law, however you might have brought it in domestic law, we would characterize it as a contract claim. And then it says the question whether it's a contract of employment claim depends on whether he's an employee. And so since the claim itself is relying on a provision, as your lordship made the point yesterday, paragraph 19, it's bringing a claim based on these obligations which are owed to Holterman consensually. All it's actually saying, the only question the court's answering, dealing with in this case, is was this person an employee?
Yes.
Probably an employee.
Well, yes, it approaches the first question by first of all asking whether the person is an employee, and then having done that, at 48 it then turns to what the implications are. If the referring court were to find that Mr. Spies had a bond with Holterman through an individual contract of employment, it would be for that court to apply the rules on jurisdiction laid down in Section 5. And then we get the formulation of the answer.
But the formulation of the answer matters because the formulation of the answer carries within it the court's view. What is it that they have to look at? He has to, in his capacity as director and manager, have broken these duties. So what they're actually saying is you have a contract as director and manager. You're relying on these obligations in respect of that relationship, his position as director and manager, which is a contractual position. If there is a breach of those obligations, if he is in fact an employee, then you have a case which falls within Article 18 to 20.
We haven't looked at it yet, but the way the court deals with the second question seems to me to be the same. If one reads on to paragraph 50, by its second question, the referring court asks whether Article 5.1 must be interpreted, etc. So paragraph 51, that question is relevant if the referring court were to find, after examining the evidence, that Mr. Spies did not perform his duties as an employee. So you only look at Article 5. So if Mr. Spies here was performing his duties as an employee of Holterman, then Article 5.1 simply doesn't arise.
Well, that is because Article 18 to 20 does arise. They're not saying, this is saying nothing about the relationship between Article 5.1 and Article 20, save for this, that if you're in Article 18 to 20, that means that you won't have a claim under Article 5.1 because Articles 18 and 20 are, in this sense, superior. If you're in Article 18 to 20, those are the provisions which apply. And that is what they're saying.
With the question, what are the consequences of the classification?
Exactly that.
Rather than how should the classification should be carried out?
Exactly that. That's the way the question was put, and that's the way the question is answered. What are the consequences of the classification of this as a claim under Articles 18 to 20? The consequence is you can't bring 5.1 and 5.3. What this isn't saying, contrary to what my learned friend suggested yesterday, is that in considering whether you're in 5.1, whether you're in Article 20, you have, for example, to have a look at 5.3 as well. It works exactly the other way around. Can I just identify, I will come back to Holterman. Learned friends watching the time, and so am I.
Well, bear in mind, we started a few minutes late, and you're entitled to, you indented till 12:30. I think you can take that as being 20 to 1, and we'll sit slightly late to finish.
Grateful, thank you. I'd identified 2 points relating to difficulties with my learned friend's case. The second point being the difficulty that arises in having to investigate whether there's a breach of an implied, whether you could have pleaded as a breach of an implied term, and how do you identify that? Because that's my learned friend's test. Could you have pleaded this as a breach of an implied term? How do you determine that without having evidence about the proper law of the contract in question and investigating whether you could have pleaded as a breach? My learned friend suggests, in responding to this point, that our test is equally difficult to apply, but with respect, that is not right. Our test simply requires that the court look at the claim form, or the claim that is brought, look at the data that provides in terms of the obligations relied upon and the facts and matters relied upon, and that you characterize them at an autonomous European level. That doesn't require any investigation going beyond the pleading. The learned friend then, I think, took you in this context to Kalasa, which was a case in which the European Court said there may be occasions on which you do have to have some investigation of the facts, but you shouldn't allow this to develop into a trial where you're having to investigate all the issues. But of course, the issue that arises in Kalasa is whether, in that case, there was a contract at all. If one party says, I have a contract and my claim is on a contract, and the other party says, there never was a contract at all, and therefore you can't bring a 5-1 claim at all, the court has to do something to investigate whether that is right or not. With respect, that says nothing at all about the appropriate test at the point at which we're dealing with it.
I see that.
The third point we make about my learned friend's test is that it produces arbitrary distinctions in treating identical cases differently. Take, again, the deceit claim involving 3 people, or even a conspiracy claim involving 3 people. Just because one of those people may have a contract, or perhaps they all have contracts, but one person's contract does include, or could include, the implied term, and the other 2 individuals' contracts couldn't include an implied term of dishonesty. There are 3 people, one of them has a contract. In my learned friend's case, if I plead a claim in deceit against those people, for 2 of the 3, that would be a 5-3 claim. But for the third, because I have a contract, even though it's completely collateral to the matters complained of, he would recharacterize. And in our respectful submission, if that is the conclusion that one arrives at, then in my respectful submission, you know something has gone wrong with the test.
But Article 18 does that on any view, doesn't it? I mean, it forces you to sue in a particular place, even though you may be wish to join a whole lot of the employee to proceedings in some other place, or you may wish to join a whole lot of other people to employees against the proceedings against the employee. You can't do it because Article 18 forces you to a limited number of jurisdictions for the benefit of the employee.
Well, my Lord is pointing to the fact that falling within certain rules has certain consequences. I'm pointing to a different point, which is that conceptually you have exactly the same claim made on the basis of exactly the same facts against 3 people, and on my learned friend's test you characterize 2 of them as tort claims and one of them as contract claims because there is a contract which is completely irrelevant.
So, if it's completely irrelevant, then it's obviously completely irrelevant.
Well, it's completely irrelevant to the claim which is made. My learned friend says, because I could plead an implied duty of honesty, it becomes relevant. But it only becomes relevant on the basis that he says, because I could have pleaded an implied term of dishonesty. It is not relevant to the actions about which I'm complaining.
I think it becomes relevant because European law regards this as a situation in relation to the employee or the contracting party, which has arisen out of a contractual relationship, and it imposes special jurisdictional rules in that case.
My Lord posits,
normally, the problems don't arise because you can use Article 6 to join third parties, but if the contract is with an employee, you're confined and prevented from doing that.
Well, my Lord posits a conclusion, which is precisely what we are arguing about, whether Articles 18 to 20 does require that. In my respectful submission, it doesn't. And also, again, my Lord says Article 6 enables you to cure the practical problems. With respect, it doesn't in the context of the Lugano Convention.
I'm not positing conclusion, I'm simply
but the way you're
putting points for you to deal with.
that is what we're arguing about.
Yeah.
Presumably there could be some oddities. I mean, if somebody induces your employee to breach his contract, you sue your employee in contract, but you would sue the inducer in tort.
You would.
And there
the
would
matters
then
you're
be a
complaining about are different.
There would then, they're different cause of action, but it still would be pretty inconvenient. But I see, it's not the same point, I see that.
That's not the same point. And moreover, Kelfalis, your Lordship will recall Kelfalis, there is a bit in Kelfalis about channeling, which is the notion that because you have one claim, which is a contract claim, you can treat everything related to it as a contract claim. And it rejects that. That is not part of European law, which is why one needs Article 6 for cases which fall within it.
But I see the force of the point. You could sue you have to sue 2 conspirators in one place and the third in another.
And it gets, and exactly this is exactly this case. It gets, in my respectful submission, worse, because what my learned friend's case produces, and this is my next point, is a complete wedge between characterization for the purposes of jurisdiction and characterization for the purposes of choice of law. My learned friend does not say that in the context of choice of law issues, there is any non-cumul principle. He accepts that for the purposes of choice of law principle, he certainly can't argue that this European law says anything other than this. A tort claim, which I plead in English law tort, doesn't say the Brog-Sitter rule applies to choice of law. So that would be a tort claim, or my claim would be a tort claim, but he wants to assign it to a court, which is the court to which you would assign contract claims. Now, that, with respect, goes completely against the policy of this European legislation. Can I just identify for your lordships, take your lordships to the Rome Conventions, just to show your lordships recital 7 of each. You have, they're both in volume 1, behind tab 4.
Yeah.
Behind tab 4A, that's beginning at page 1125,
Yep.
you have Rome 2.
Yep.
If your lordships look at recital 7, substantive scope of the provisions of the regulation should be consistent with Council Regulation 44/2000, that's the Brussels regulation on jurisdiction, and the instruments dealing with the law. And Rome 1 has an identical recital, again, it's recital 7.
Yep.
So in other words, what one is looking for here is consistency between choice of law and jurisdiction. And that makes sense because you obviously want the matter to go to the court which is going to be the proper law. I can put it that way. Can I also show your lordship in this regard Ergo Insurance, 452, page 2359 and page 2370.
Yep. Yep.
Sorry, can I have that page again?
We're looking for 452, page 2370. Just looking at paragraphs 43 and 44. I invite your lordships to look at paragraphs 43 and 44.
Sorry, which tab is it?
Behind tab 52, page 2370. We're in bundle 4. So my learned friend can't just say, well, choice of law is different and difficult, but at least we can do this non-cumul approach on the jurisdiction level, because with respect, he's not suggesting, as I say, and there's certainly no authority to suggest we have a non-cumul policy at the choice of law level. His approach produces an inconsistency between choice of law and jurisdiction, which is contrary to what the European Court said the position should be. Now, that was all I was proposing to say.
It does mean that, I mean, if this is right, it does mean that there is some recategorization at the European level, doesn't it, for the purposes of proper law? Because you are obliged in deciding whether Rome 1 applies rather than Rome 2 to look at the European conception of a legal obligation freely consented to.
No, there's no question about it. In Rome 1 and 2, as well as in the Brussels Convention, where he's dealing with autonomous contract and autonomous tort concepts. But what you don't have is anything at the choice of law level which in effect is a non-cumul policy, which says you're obliged to bring it as a contract claim if you could have. And that's where the dislocation happens on my learned friend's test. Can I then just turn to, that's all I was proposing to say about the second point, which is the classification or characterization point, as I submit. That is the perhaps the main point in the case. One then has the cases my learned friend refers to Brog-Sitter, Holterman, and Granarola. And to some extent, we have covered a lot of the territory in relation to those. So I'm not proposing to go back to those in any detail.
But you've said quite a lot about the paragraphs in Brog-Sitter.
We've said quite a lot about the paragraphs in Brog-Sitter. In our respectful submission, You have them in our written case.
Yep.
You cannot ignore paragraphs 25 and 26, and they direct your attention to the legal basis of the claim made, and they ask whether in relation to that legal basis the contract is indispensable, and that in our respectful submission is
So
no
can we just look that quickly down? What's,
452, Broxit is at 445.
Yep.
The relevant page is
The
at
vital paragraph 2250.
2250.
Yep.
There's 25 and 26. 24 is the introduction. That will a priori be the case when the interpretation of the contract which links the defendant to the applicant is indispensable to establish the lawful or, on the contrary, unlawful nature of the conduct complained of, or against the former by the latter. It is therefore for the referring court to determine whether the purpose of the claims brought by the applicant in the case in the main proceedings is to seek damage, the legal basis for which can reasonably be regarded as a breach of the rights or obligations set out in the contract which binds the parties in the main proceedings, which would make its taking into account indispensable in deciding the action. So it has a requirement of indispensability if this is going to be a contract claim. And my learned friend's case, that supports our case, if I can put it that way. You're relying on an obligation in relation to which the contract is indispensable.
I see that.
The other point we make about Holterman, in terms of the two interpretations, is that so far as our interpretation, my learned friend seeks to get rid of 25 and 26 on the basis that they're examples. We've made our points as to why it is impossible with respect to treat these as examples. They're part of the test. And that is how they have been regarded in the subsequent cases. I'm going to come to what the subsequent cases say about that now, and I'll deal with that very quickly. But your lordships will note in Broxeter, there is a reference back, for example, to OFAB, which is one of the cases I took you to at paragraph 18, and again at paragraph 19. What you don't find in Broxeter is any suggestion that they're departing from the established jurisdiction here, or jurisprudence. So far as the court in Broxeter is concerned, which plainly thought this was so simple it didn't need an advocate general, so far as it is concerned, it is formulating a test which is certainly not a radical departure from what has gone before, because it appears to refer to OFAB with approval. But on my learned friend's case, that must be what is happening. Now, in terms of the rival interpretations for Broxeter, as your lordships know, we say you can't ignore 25 and 26. What we say is supported by what the Advocate General said in Holterman. If your lordships want to look at that, that's volume 4, tab 52, page 2324 is where it starts. But if I can invite you to look at paragraph 48 at 2339.
Thank you.
Your Lordship, see the Advocate General here referring to Broxeter and saying it is for the referring court to determine whether the actions brought by the applicant constitute a claim for liability that might reasonably be considered to be based on a failure to respect the rights and obligations under the contract for the purpose of the regulation between the parties, with the result that it is indispensable to consider that contract in order for the case to be resolved. So again, relying on the indispensability point. Your Lordships go back to paragraph 34 at page 2336. Again, from D to E, your Lordship see again a formulation which involves reference to the need for the contract to be indispensable.
2336.
2336, paragraph 34.
Yep. Thank you.
And again, at paragraph 71 of the court, my Lord Reid took us to that earlier, Again, there is a reference by the court there to paragraphs 24 to 27. That's at 2356. Now, it's not only the AG in Holterman who interprets Brogsitter in the way that we've suggested. The AG in Granarola is also in line with what we say. If your lordships, if I can invite your lordships to go to tab 55 in the same bundle, beginning at page 2407.
Yeah.
And if I can invite your lordships just to look at page 2413, paragraph 11, and then paragraphs 13 and 14. Lordship sees again the reference to indispensability as part of the test. Should just make the point in relation to the debate between us as to whether paragraphs 25 and 26 are examples or not. We referred in our written case to the German text of paragraph 25. That's at page 38, internal. That makes it clear that what, certainly as a matter of the German, is being said is that this is in principle the position, if rather than by way of some example. And one has, I think, the same said in the article by Van Kelster, which we've included in the bundle. That's the Respondent Supplemental Bundle, tab 7, page 110. Van Kelster makes the point about the German translation of.
Yep.
So that is what we say about Brogsitter. Not only what we've said, but also what the various Advocate Generals have understood it to be saying. My learned friend, in relation to Granarola, in his written case, said that the court disagreed with the formulation of the Brogsitter test, which the Advocate General had adopted in Granarola. In our respectful submission, what the court disagrees with the Advocate General about in Granarola is whether there's an autonomous contract on the basis of that statute. There is not a single word in the judgment of the court which suggests that they disagree with the analysis of Brogsitter. They just disagree with the premise, which is that the French statute, the Advocate General proceeds on the basis that that is not, doesn't give rise to an autonomous claim. The court says that it does. That then takes us to Holterman, which again we've largely, I think, covered. The one point we would stress about Holterman is the points we've already stressed. The whole analysis that follows paragraph 32 is predicated on Brogsitter. My learned friend accepts that Brogsitter, is predicated on Brogsitter. My learned friend accepts that Holterman also, even for the purposes of section 5, he accepts that you would have to satisfy what he says is the trigger test, which is that the claim must be one which you could have brought in contract, whether or not that you do. And in that sense, it goes no further than Brogsitter. But in our respectful submission, my learned friend's main point about Brogsitter, certainly in his written document, was the suggestion that the Article 2.9 was a freestanding independent claim, which the court in Holterman said you could bring in Section 5, notwithstanding that it was a freestanding claim. But with respect, that is, may not be exactly the opposite of what the court in Holterman is finding, but it is not what the court in Holterman is finding. What the court in Holterman found was that there was a contract in relation to the duty of director as well with the parent company, and that the claim being brought on the basis of a breach of that duty, which the European Court would characterize as a contractual duty, the only issue that had to be determined was the issue as to whether Mr. Spies was in fact a director, which is why from paragraph 33 to 37, that is what the court is dealing with. And the conclusion at paragraph 48 and 49, which is predicated on the question whether he is or isn't a director, proceeds on the basis that A, there is a contract claim in relation to his duties as a director, and B, that is the way in which the claim has been brought. So, contrary to what my learned friend says, Holterman is not authority for the proposition that even if the claim is independent of contract, you can bring it into Section 5. Now, just on Holterman, because it is relevant to where we go next, which is the question of the group companies, your lordships will have noted that at paragraphs 39 to 41 of Holterman, the Court of Justice lays down criteria for testing whether, in that case, Mr. Spiss, but generally, a person is an employee for the purposes of Article 18 to 20.
Yeah.
And your lordship see that the Court of Justice stresses whether the relationship has created a lasting bond which brings the worker to some extent within the organizational framework of the business undertaking or employer, and they are linked to the place where the activities are pursued, and then one has the relationship of subordination, which one sees at paragraph 40. In our respectful submission, those are all important points to have in mind when we move to the second issue. Can I then just move to that issue? I haven't said anything about the English authorities, but your lordship see what we say about the English authorities. In our respectful submission, they're all pre-Brexit. None of them have had the kind of analysis that this court, I use the word treated advisedly, have been treated to. And to some extent, therefore, the analysis in Alpha Laval does not really assist.
Understand.
And we, just finishing before we get into the breach of fiduciary claim, we say that in relation to the conspiracy claim, those are all allegations which arise independently of the contract. And that being so, this is properly characterized as a tort claim, and that being so, it cannot come within Section 5. Now, so far as concerns the fiduciary duty part of the claim, there are, in our respectful submission, two overriding points, and this is really about the group entity point, which applies to both parts of the claim, but there are two overriding points which emerge from my learned friend's written case, and I have in mind in particular paragraphs 118, 119, and 121. The first is that although my learned friend, I don't think, puts it this way, what he is actually arguing for here is the existence of a special rule which applies in circumstances where one group entity employs an individual. And the special rule for which my learned friend contends is that in a situation such as that, the individual, he would say, should be regarded as employed and employed by the group as a whole. That's his first point, that in a group situation, an employee should be regarded as employed by the group as a whole.
Understand.
What I would say about that, my lord, is that there is no support for this at all from any European case. In our respectful submission, regardless of whether one has a group situation, what the employee still needs to show is that he had a contract of employment with the entity that is suing him. Article 18 to 20 is predicated upon a claim by an employer against an employee. If a claim is brought by someone who is not the employer, then the difficulty for my learned friend is trying to explain how, notwithstanding that that person is not the employer, the claim comes within Article 18 to 20.
Well, his submission is consistent with the broader principle underlying a very large number of provisions of EU law, that EU law is essentially concerned with economic units more than legal entities.
It is consistent with that, but in the context of jurisdiction issues, there is no principle to that effect. In fact, what one has, and in particular in Kalasa, which admittedly is about consumers rather than employees, but the principles are the same. You're there to protect someone. Is the Advocate General, I think I took you to this yesterday, saying, notwithstanding that these are provisions here to protect a particular individual, we should construe them in accordance with the language used, and if they don't get into the language, then that doesn't apply, because this is a balance to be struck. LASA also rejects, Your Lordship will recall, what it described as the economic theory, which is just because there is an economic benefit felt, you should be regarded as coming within.
It's not just the economic benefit. It's a bit unreal. You started off by saying there's no special rule whereby one group entity, where when a group entity employs an employee, he's treated as being employed by all members of the group. Well, of course, one agrees with that. You can easily be employed by just one company. But these people, the defendants, these two, they acted as controlling officers of all the companies of the group. They acted for all the companies in the group. They ran the business. In European terms, if you can find a voluntarily assumed relationship amounting to a contract where there's no domestic law contract, you can easily find a voluntarily assumed employment contract relationship, can't you?
But I accept that if you can actually find a contract, then you don't need a special rule here.
In European terms?
In European terms. If you can find a contract in European law, then you don't need a special...
A non-contractual agency is probably a pretty good example of a situation where there is a mutual and consensual set of obligations, whether contractual in national law or not.
My Lord, yes. And
That's essentially what happens, isn't it, when a service company of a group employs everybody, and that they're employed to act as agents for each of the companies of the group.
if those are the facts, then yes, those aren't our facts. I'm not saying you couldn't, in a group situation, have a contract of employment with a number of the entities in a group. I'm saying that's
not the point. The point is that you can have a contract of employment with company A, which involves acting as agent of companies B, C, D, and E, and the agency may be non-contractual in national law terms, probably would be non-contractual in national law terms, but it would fit the bill as far as the EU definition is concerned.
I accept that as well, my Lord, and I accept that it is therefore possible to have an analysis which, on the basis of we have an analysis which says that whether or not there is a contract in English terms, national terms, you may have a contract in European terms. The question that then arises is whether the contract is one of employment, because you have to, in relation to the other entities, take the entities here, Arcadia, Switzerland, with whom he never had a contract. Let's use that as an example. What has to be said by my learned friend is that in circumstances where not only did he not have a contract, but he strained every sinew, I think was the way Mr. Howard put it, which the court below liked, not to have a contract with these entities, where he effectively controlled what he wanted to do. Indeed, he controlled who he was going to have a contract with. The facts that arise there are sufficient to regard Mr. Bosworth and Mr. Hurley as having a position of subordination to those, we call them non-employing companies, the companies with whom he had no written contract, in relation to whom there was no one who told him what to do in those companies, in respect of which they decided whether they were going to have a contract of employment with those companies, or if they were going to have a contract of employment, on what terms they were going to be. Does this come within the concept of employee for the purposes of paragraphs 39 to 41 of Holterman? Is there, in relation to those relationships, long-term bond, integration in the business, and most of all subordination? The facts in our respectful submission in relation to that make it impossible for my learned friend to say that in a case as here, where they deliberately avoid having a contract for their own tax purposes, they deliberately ensure that there isn't a contract.
Yeah, we got that.
That there is, notwithstanding that, a contract which gives him the protection of an employee. Now, in terms of facts in relation to this, my Lord, I don't think I have time to go through the facts. Can I just give your Lordships perhaps even read into the transcript, the references to the facts
Yes,
that we
do
relied on. So far as concerns Mr. Bosworth and Mr. Hurley's control,
Yep,
the Adams affidavit, that's the original affidavit in support of the freezing and proprietary injunction. It's in volume 2 of the appendix,
Thank you.
tab 23,
yep,
paragraphs 89 to 94, which is pages 811 to 813.
thank you.
Paragraph 96, which is at page 814, and paragraph 102, which is at page 816, as well as pages 103 to paragraphs 103 to 4, page 117, and paragraph 108, which is at page 819. And just to briefly identify for your Lordship what those are about, paragraphs 89 to 94 provide the account of the original purpose, and they make clear that Mr. Bosworth and Mr. Hurley were actually responsible for the sale of the business to Arcadia.
Yep,
What Arcadia was actually buying was Mr. Bosworth and Mr. Hurley.
understood.
Paragraph 96 makes the point that it was left to them. Paragraph 102 points to the reference to continue with the efforts to improve structures. I think the learned friend yesterday relied on paragraphs which showed that as one got to the end of the relationship where someone smelt a rat and thought there was a fraud going on, more was done to try and control these employees. But that, with respect, doesn't begin to reflect the relationship, which was one under which there was very limited or almost negligible control of them. They were left to run the
Understood.
business as they
Yep,
The only other point I was going to make about the fiduciary duty part of the case, or the group part of the case, is this. Your Lordships may wish to look at paragraphs 119 and 121 of my learned friend's...
Same
119 and 121 of my learned friend's case at page
Right.
41. The reason I refer you to it, if I can just take this quickly, because
Yeah.
I'm running out of time,
you can.
is your Lordships want to have a look at what my learned friend says is the test which is to be applied
Yep.
in the case of group entities. Because what he has to say at paragraphs 119 and then 121,
yep,
just the last line there, says it would fall within section 5 when the conduct complained of constitutes a breach of the contract of employment with the employing company. Now, what is and if you look at paragraph 121, about 4 lines down, he says, applies when the conduct complained of could be pleaded as breach of contract. On my learned friend's case, the contract in question is not the contract which has been entered into with the claimant. It's the contract which is entered into with any of the group entity companies. And so although my learned friend says that the test that you apply is the same regardless of the conspiracy claim, whether or not you're dealing with group companies, with respect, he's changed the test dramatically here.
he's saying it doesn't have to be with the employer, it has to be with the company in the same group as the employer.
Indeed. And why stop there?
Understand.
Why not make it a breach of contract with anyone?
Understand.
My Lord, subject to your Lordships having anything else you want me to address, those are our submissions.
Thank you very much, Mr. Rabinovitz, that was very clear. Thank you. Mr. Pilbrow,
Sorry.
swap of lecterns again.
My Lords, if I may, I'll start while they're
Mr. Foxton, yes, you're welcome to start.
finding their way across. My Lords, it may appear that these reply submissions don't have any structure. They do. The structure is my desire to ensure points get out in the 30 minutes, and they have been ordered accordingly.
That's an aim rather than a structure, but never mind. Yep.
It may not be the
Perfectly
most
fair.
logical approach.
We entirely understand. Don't worry about that. Thank you.
Now, my Lords, we would submit one of the most revealing moments in the course of my learned friend's submissions came with one of those examples which in every case almost takes over the argument on both sides, the chauffeur. the taxi driver, in which we got one answer from Mr. Rabinovitz yesterday evening, the gist of which is it had a contractual context, and a recognition today that the logic of his case is that if the employer is able to sue on the basis of a tortious duty, which under whatever order it arises is not dependent upon establishing voluntary assumption of that duty, the employer gets to sue in tort. Now, my lords, the effect of that argument is to take outside of Section 5 claims by employees insofar as they are premised upon breach of health and safety legislation, which is not, we would say, a claim that is dependent for its actionability outside contract on the voluntary assumption of duty. The employee who crashes the forklift truck into some plant and is sued by the employer for damaging it. The employee who wants to sue his employer for a latent occupational disease and needs the benefit of the limitation period applicable to tort claims because the contract period has passed. The employee who wants to sue his employer on the basis of a statutory right not to be discriminated against on grounds of age, gender, or sexual orientation, which are, after all, perhaps the most classic examples of obligations that are owed independent of any voluntary undertaking not to assume them. And it also allows considerable scope for preemptive litigation by an employer who, if he's able to sue in deceit the employee who he has sacked for falsely claiming overtime or claiming a sick day when the employee was not in fact sick, will get his action first seized for the purposes of the lees alibi pendens provisions of the convention in whatever national court he's able to establish jurisdiction, whereas preempting, in effect, the employee's contractual claim within Section 5 for unfair dismissal. Now, my lords, if one stands back and looks at the purpose of Section 5, we say none of those are remotely tenable outcomes. And if one looks at the commentators who have particularly looked at Section 5 on employment, and Professor Merritt being prominent amongst them from an English law perspective, they would not support that analysis, and we would submit for very good reason. And of course, one is not dealing here with the question of whether Section 5 applies at all. The very reason we're having the argument is that it's accepted that Section 5 applies to a claim insofar as it's brought in what is autonomously regarded as contract. The question is whether the protection that that affords should, as a matter of interpretation, not be extended to claims which are brought in tort for exactly the same conduct or not. And we do submit that when viewed from that perspective, it is entirely appropriate to test that question of interpretation by reference to whether it would serve the social purpose of Section 5. Because if you do not extend Section 5 or apply it to concurrent tort claims, that involves a very serious inroad on the protection which clearly Section 5 is intended to give, which I think Lord Justice Sales in Petter described as giving the employee the right to be sued in his domicile in relation to employment matters.
Yep.
Now, my lords, we do rely on Halterman as the case which establishes that Section 5 is to be read not simply as a particular subset of claims which would otherwise fall within Article 5.1. And your lordships have seen, and I'm sure when reading through the case will bear in mind, that one cannot focus simply on the company law claim under Article 2.9 of the Dutch Civil Code. One has to keep in mind the tort claim under Article 6.169 at all times. The court had not determined that every claim before it would otherwise fall within Article 5.1. If it had, the third question would never have arisen, nor would there have been the question referred back for the national court, as there was under section 3, under question 3, does this fall within 5.3 or not, if it's found that Mr. Spies is not an employee? And if one looks at that third question, the question that is being asked is, can the unlawful conduct, the tort claim, be considered to be a breach of the company law duties? That cannot be asking, has it been pleaded as a breach of the company law duties? It's plainly asking whether the same conduct can give rise to a claim under both provisions of national law. Now, in relation to the question of Mr. Spies being an employee, my Lord Sumption raised the question of whether the Commission had suggested in that case that one had to look at whether the circumstances giving rise to the claims were in relation to matters where there was subordination or not. And
well, they appeared to regard subordination as the identifying characteristic of an employment relationship in relation to the particular complaint.
Lord, I would certainly accept they regarded subordination as a characteristic of an employment relationship. Those of us who are independent contractors very often regard ourselves as subordinate as well, but clearly the ECJ are able to distinguish between the two. My Lords, where we would part company with that analysis is to suggest that the question of subordination falls to be analysed by reference to whatever the particular activity is that's given rise to the claim. That would appear to suppose that the same individuals could both be employees and not employees in relation to claims brought by the same entity who would be their employer and not their employer.
Well, it presupposes that some claims may arise out of acts characteristic of an employee, but others are not characteristic of an employee, but simply done by somebody who happens to be one.
My Lords, one difficulty with that what's of Schrodinger's cat approach of both employee and not employee is that it undermines the predictability that the regulation or the convention are intended to give. It also exposes itself to the danger of the argument that would sometimes be run in vicarious liability cases under English law, that somehow if what the employee is doing is a breach of his contract and not what he's employed to do, therefore he's no longer acting in the capacity as employee. So well, we would suggest that the Commission in Holterman contemplated a single answer to the question, was Mr. Spies an employee, which would have applied for all purposes. Now, my Lords, on the group of company issue, I'm afraid I too was proposing to read some references into the transcript for your Lordships to consider if
That's
that would
fine.
be
Yep.
permissible.
Say bit.
It is important to look at how the cases pleaded against
Yep.
Mr. Bosworth and Mr. Hurley. And the re-amended points of claim are at Core Bundle 2, 12, and invite your Lordships in due course to read at page 469, paras 9.5 and 9.6, page 473 to 474, paras 10.5 and 10.6, and also to look at the statement of facts, Core 1, tab 6, page 70, paras 10.1 and 10.2. And as we made clear in our submissions yesterday, we put our argument forward on what I've called both the Simango-Turner and the Petter basis. The Simango-Turner basis involves looking at obligations owed to other group companies and saying, from an autonomous European perspective, those are part of the individual contract of employment. The Petter basis says that they are intrinsically linked with the individual contract of employment, and that is enough to bring them within Section 5. Lord's characterisation, Mr. Rabinovitz said you will find no case in which the court looks around when faced with a claim pleaded on an ostensibly delictal basis, saying, well, hold on a minute, could there be a contract here? That, of course, is Granarolo. Ambrosi were not alleging this was a voluntary relationship. They wanted their tort Article 5.3 jurisdiction in France. The court were not saying every claim for rupture abusive is in its nature inherently contractual. If the court was saying that, there would have been no need to remit the question back to the national court to find out whether, as a matter of fact, there had been the long-standing tacit relationship between the parties. What the court did do, and we say it is striking in this respect, is although the claim had been brought based upon the statute, the court said, well, we need to find out whether this relationship is arguably contractual, because if it is, that claim will fall within Article 5.1. It must follow from the court's analysis that if you could not meet the requisite finding when you got back to the French court on all the evidence of the long-standing relationship giving rise to tacit agreement, you would not be within 5.1 but 5.3. So that is a very clear case in which the same conduct, which absent any autonomous contract between the parties is a 5.3, comes into 5.1 because there is an autonomous contract between the parties. Now, my Lord, so far as Dr. Scott's article is concerned, I'm just going to give a couple of references, because the article is an article on choice of law, and Dr. Scott makes plain in two passages in that article that he thinks different questions arise when one is considering the application of jurisdiction regimes. That is Bundle 8, tab 87, page 3583, page 63 of the article and footnote 22, and also page 68 on page 3588. When the characterization argument was being put, Mr. Rabinowitz would occasionally slip into the shorthand of saying the effect of our argument on Brog-Sitter is you were precluded from bringing a claim in tort. I accept it is a shorthand. It is a shorthand that is apt to mislead, because you are not precluded from bringing your claim in tort. Your claim in tort remains your claim with whatever you need to prove under national law to establish it. All that happens, though, is that claim, like your cumulative contract claim, goes to the court, the same court under Article 5.1. So nothing here takes away the ability to bring a claim in tort with whatever forensic advantages that might bring. But what it does do is avoid the unpredictability and risk of inconsistent findings that involve separating claims arising from the same conduct into two different courts.
Yeah.
And, although I don't suggest we turn it up, that's a very point that Advocate General Jacobs makes in Hanty at Authorities 3, tab 33, page 2007 at paragraph 24. Well, it's a very short point on this. I think Lord Mance suggested that in OFAB, the argument might have been open to say...
In which case?
In OFAB.
Oh, yes, quite. Yes.
Why couldn't they sue and say this was a breach of the director's contract by failing to prepare the balance sheet? Well, the Swedish statute gives the cause of action not to the company to whom the directors owed their duty, but to debtors. The effect of the statute is to make the directors jointly and severally liable with the company for the company's debts. And the claimant in that case were the creditors of the company, not the company. So there could have been no possibility of treating the director's conduct as giving rise to a claim in contract between the same parties as well as in tort. My Lord Mance also asked whether the Pocar report told us anything about the coming into being of Section 5. And, my Lord, it is worth having a look at. It's in Authorities Bundle Vol 6, tab 64, and the paragraphs that look at what is happening on Section 5 in employment are paragraph 52 on page 3105 and paragraphs 85 to 89 on 3115. Our report describes Section 5 as, quotes, an independent and comprehensive code. And one of the important changes that Section 5 did bring in was the right of the employee to be sued on the place of the employee's domicile, Article 20. And of course, that inevitably raises a question which does not arise before there is such a right, namely, can you circumvent that protection when there are cumul claims by suing in tort? With respect to my learned friend, Mr. Rabinovitz, that Article 20 provision is new and raises as a matter of fundamental interpretation, if it's to be given effect, how it applies to cumulative tort claims. Now, Lord, I think that may leave Gabriel and the prize cases. And briefly going to have a look at that, because although it's on a different protective jurisdiction, Section 4 in consumer contracts, we agree with Mr. Rabinovitz, it is not without interest. Lord, we've got that in appellant's supplemental authorities at tab 3, beginning on page 89.
Sure. Yes. That's right.
And my lords, it's one of a number of cases concerned with this rather attractive Austrian law that if someone sends you a communication that would lead you to believe you had won a prize, you get to sue for the prize. There's a lot to be said for extending it to material saying if you remit a facilitation fee, it will free up substantial funds trapped in a bank account and you get your share. Now, the question in that case was whether the claim to recover the prize under the legislation fell within Section 4. And that was a case in which to make yourself eligible to claim the prize, you had to order some goods. And goods indeed were ordered of a small value by Gabrielle.
Yep.
And it's quite important when looking at the Advocate General Jacobs' opinion, page 98, para A30. He is not asking himself the general question, is the prize law a claim autonomously contractual or autonomously tortious? He asks himself the much narrower question about whether the claim to enforce the prize falls within Section 4 when you do order some goods. And you order some goods as a condition of being able to claim your prize. And that is the question, as we see at A30, that he asks himself. And he's faced with some arguments. If one looks, for example, page 99A34 from the Commission, that this all turns on whether it's an offer or an invitation to treat. Now, Advocate General Jacobs' suggested answer at A35 is it falls within Section 4 because of its close connection with a contract that falls within Section 4. It's not a question of the classification of the prize. It's a question of it being, it's put, I think, in the judgment, indissociably linked with a contract that did fall within Section 4. My lords, if one goes forward to A43 on page 101, in adopting that approach, the Advocate General, as regards to the need to ensure the Convention is fully effective as an interpretive tool of Article 13. So this is the purpose of the Convention being prayed in aid to determine whether Section 4 applies at all. Para 46 notes the argument put the other way. Well, this should all be construed narrowly as a derogation. And we say rightly makes the point that that cannot trump the need also to construe the provision to be effective. And it is striking, we say, if one looks at paragraph 48 of the opinion, the bottom of that page, that one of the concerns which the Advocate General has is the ease with which Section 4 could be evaded if you allowed a party to take their stand on differences between, for example, offers and invitations to treat, such that by tinkering with the format of communications, you could take it outside Section 4 when it would otherwise be in it. Now, my lords, the relevant paragraph in the judgment is at paragraph 54, first of all, on page 113.
Thank you.
And once again, we see that the claim by Gabrielle against Schlank and Schick got in not because the court classified the prize law claim as contractual, but because it was intimately linked to a contract which did come within Section 4, an indissociable relationship between the two. And paragraph 56 on the same page in support of that view, the court, not remotely attracted by an argument that would have the sale of goods claim within Section 4 and a contract indissolubly associated with it outside. So, Lords, if any assistance is to be obtained from the prize cases, we say this assistance in support of our case, there is a very good analysis of those cases, which I think caused Professor Briggs some amusement in his book on the convention. But we say that the recognition that claims under in this case is a separate contract, but indissociably associated with a contract falling within Section 4 brings both claims within the section, offers some helpful parallels to the arguments that this court is considering in relation to the tort claims and Section 5.
Yeah.
Lord, I'm very helpfully reminded by Mr. Schwager of two final matters. The unlawful means in this case, for the purposes of the conspiracy, were originally breach of the employment contract and breach of fiduciary duty. The unlawful means of breach of the employment contract went in the post-jurisdictional challenge amendments. They've since been supplemented by various others, including knowing assistance and knowing receipt. So we have accessory liability as an unlawful means for accessory liability, which all credit to the ingenuity of the pleaders. But the suggestion, we would say, that Section 5 turns upon that sort of ingenuity of analysis is a surprising one.
What do we have? We have instead unlawful means consists of, again?
Currently, breach of fiduciary duty, knowing assistance,
So it's other accessory.
and knowing receipt.
Yeah.
And I think deceit as well.
Okay. Yep.
And, my lords, finally, subject to any other reminders I receive, I do invite your lordships to check the footnote where it is said that Dr. Hess recanted his views in the Heidelberg report. It doesn't support the assertion made about it. It is a German law textbook in which he comments on, quotes, the prevailing view under German law. He gives a footnote to another
Can you
German
give us
jurist.
the page number? Sorry.
Um,
Just remind us.
Lord, it's bundle authority 7,
Yep.
tab 77,
Thank you.
page 3333.
All the sevens and all the threes. Thank you very much. Yep.
So where is the footnote? Somewhere
On that page.
In some
On that page.
Oh, on that page, I see. Yeah.
It's
What about?
footnote 527.
Yeah. What about? You mentioned Professor Merritt's work which I said I'd had a brief look at. What about other commentators? Are there particularly worthwhile passages or passages on the same subject which we ought to look at?
Well, people writing on the regulation and employment have had a surge in royalties as a result of this appeal. There is a book by Associate Professor Grusic on the European private international law of employment.
Do I take it from the fact you're looking at it that we haven't got copies?
We have a copy of the section put forward by the respondents dealing with choice of law.
Yeah.
That section itself argues differently as to jurisdiction. Your Lordships don't have the section dealing with jurisdiction from this book. It's clear from the section Arcadia did put in, and they accept that he is arguing for a different outcome within Section 5 on jurisdiction, and they say that is wrong. But we could provide your Lordships with a copy of the relevant pages if that would be of any assistance.
It's an English book, is it?
It is an English book.
Yes, well, it could be quite interesting to have. What about any of the other voluminous references in the bundles that one should look at particularly?
Lord, we've got Professor Briggs's views, and those are in the bundle. And I think Mr. Rabinovitz has pointed out, certainly in relation to our interpretation of Brogsitter, that our line has been Professor Briggs's analysis from the outset.
Yep.
Written before engagement, yes.
Absolutely, my Lord.
Right.
Lords, unless I can assist any further.
Thank you very much indeed. Well, thank you very much for dealing with all our questions, and thank you both for your submissions in this appeal. Thank you also to all the parties who were involved in preparing the written cases that we found very helpful. We will consider this matter and let you know our decision in due course. Thank you all very much. Court's now adjourned.